Welcome back to Breakfast Central. In a courtroom drama that unfolded yesterday at the Federal High Court in Abuja, Nnamdi Kanu, the detained leader of the indigenous people of Biafra, made a move that stunned even seasoned legal minds. He sacked his entire legal team led by the former Attorney-General of the Federation, Chief Kanu Agabi, and declared that he will defend himself in his ongoing terrorism trial.
The man at the center of one of Nigeria's most contentious legal battles has chosen to go solo. No senior advocates, no legal shields, just him, the Constitution, and the court. But what does this mean for the rule of law, for the integrity of the trial, and for the future of the separatist agitation in Nigeria? Joining us for this discussion is legal analyst and constitutional lawyer, Mr. Jide Ologun, to unpack this twist to the case. Thank you very much for joining us.
You're welcome. It's my pleasure.
Prior to Nnamdi Kanu's decision, now this is not the first time that we've seen him deciding to represent himself in court, but before now, this case has had a lot of bumps and hiccups. What is the implication of him choosing to represent himself? Maybe first of all, to put things in perspective, does he have a right to represent himself in court?
Absolutely. He has the right, which he has exercised. And the senior advocate also commented that that was his desire, and they must respect his desire. And he has chosen to present himself as his own counsel before the Honorable Justice. And he will be allowed to do that. But interestingly, there is a crucial point here. The prosecution has closed the prosecution, calling 5 witnesses, establishing the fact that he has a case to answer, because at the point his legal counsel submitted to the court that he had no case to answer, but the judge said no, from what we have here, so now open your defense. And he's expected, as the matter continues today, to open his defense. And if he fails to appropriately defend himself, as expected in the ecosystem of criminal justice, then the court will come to a conclusion, having given him the right of fair hearing, because as we speak right now, he's still under the cover of the Constitution, talking about presumption of innocence until the allegations against him are proved beyond all reasonable doubt. But like you mentioned earlier, this matter has been loaded with drama. But if you know law very well, it may not be by the drama, but following the process of the law, which is ongoing in court now. And wish him the best.
But so, is it still possible for him to change his mind and request for legal representation? Or once he's opened up his defense, he won't be able to change his mind anymore? And then the second part of my question is ask for a list of witnesses. Some of those witnesses are serving government officials, like the current governor of Lagos State, who is covered under the immunity clause. What does the law say about witnesses? Are they compelled to appear before the court if they are mentioned as witnesses?
It's discretional, and the court also has the discretion to compel some witnesses to show up. By and large, if you invite me as a witness in your matter, I can decline. And from the body language we are, seeing, it's as if there's an attempt to buy time. Because
so it's different from a subpoena?
Yeah, the court can direct that a witness you show up by compulsion if that witness is critical to that case. But some of us have sat down to wonder what the relevance of Malami, the governor of Lagos State, and some top line exactly names.
No, but Tuku Buratai was chief of army staff when his house was invaded. And
why is the drama for some of us looking at deep mind assessment may appear more like a satire? That, okay, if Buratai managed the invasion, then let him come and give witness. So I doubt if he's touching on the need to defend himself as not having committed the crime allegations leveled against him. So that is, like I said, just like buying time, you know, he started with claiming
It's
he
not
was
in
not...
his interest to buy time, because if he's buying time, he'll be spending longer time in detention.
He's been there for long. And you see, the pressure now is that the court also is not willing to play with time, because he was given 6 consecutive days from the 23rd of October 2025 to open his defense and defend himself before the Honorable Court, before this drama came in. At a point, he was asking, even when he was listing his witnesses, asking for about 90 days and things like that. And then right now, it's a very sensitive matter. But what I can say, really, is that the processes are on. The court is ready. The court has offered him the option to defend himself. I think the court even offered to get him a counsel if he became uncomfortable with his counsel. But he also declined that he will represent himself. And no law says you cannot represent yourself. But to what extent can you defend yourself if you don't have the legal skills, so to say? And if you look at the array of professionals willing to defend him, these are sound...
Leonard Silks.
Yeah, you know, so... we don't, and again, in another school of thought, they are thinking that, okay, maybe because Nnamdi Kanu is, do I say politically exposed now, or advocacy-wise exposed, that he may be thinking that his supporters will, you know, come out and begin to heat up the space, just like the end free Nnamdi Kanu protest in Abuja. But I doubt if that is going to work at this point in time, because if you have been monitoring the Nigerian space recently towards the 65th independence anniversary of the country, you know, it was rumored that some people were tempted to overthrow the government. And right now, the government is not willing to joke with the security in the land, which made the experience the Showores and his team had in Abuja visible, because government said no.
There's heightened
exactly.
security.
Don't come to this restricted area, even though you have the fundamental human rights. So that is where we are right now. And another school of thought, particularly those who are calling for political resolution of this Nnamdi Kanu matter, are saying that, okay, if the president needs the Southeast in 2027, there should be a political resolution to this. But the matter has gone far now, and because there are 3 arms of government, basically, and the judiciary is marching forward. So having said that, the Attorney-General of the Federation has the prerogative to withdraw the charges against Nnamdi Kanu. But again, it's like making the president, who the Attorney-General will delegate for, work on banana peels. Because if they now come out to say, oh, let the charges against him be withdrawn, someone will start shouting, you know, we are not allowing the rule of law. And of course, all will start shouting, oh, the president is afraid of the protests and things. So it's a very dicey, issue right now. Case. And then we leave the courts. You know, I have a deep respect for the Honorable Justice in charge of that matter to allow the laws. And right now, that case is on the track of the law. Prosecution is concluded. Open your defense. Simple.
Okay. And they'll be sitting today, as
hopefully, yeah, it's expected.
6 days. That's what you said.
6 days, consecutive. 6 days, and that is also to give accelerated hearing in the matter. So.
Okay, that will give hopefully to give a closure to the entire thing. Maybe not. But for those who are watching or joining us, just in case you did not see Mazi Nnamdi Kanu in the court yesterday while he was defending himself, I think we have the footage. It's one footage that's been circulating online. Let's get to show you.
That's what you wrote. my lord, that the defendant has now applied for bail. Now, as I've said earlier, bail is a discretion of the court, taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determine the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June, my lord, which was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. It's here. This is the law of Nigeria. But that's what you.
He has decided to conduct his defense by himself. He has a right to do so. We respect that decision, and we wish him well going forward. That's all.
Okay, so the video you saw there was the old video of Nnamdi Kanu defending himself, and he's looking to do it all over again, this time without a counsel. So the counsel have said as well, just like our in-house guest has mentioned, that he has the right to do so. So for all those who are on social media arguing that he shouldn't have done so, well, he has the right. The question now would be, he has 6 days to prove what he wants to prove. But we'll go on a break. When we come back, we'll look at the illegalities regarding this, because there are certain lawyers who feel that there's a lot of illegal processes that's been following this entire journey. Stay with us. We'll be right back. Welcome back. Still Breakfast Central, and we're looking at Nnamdi Kanu's case, where we've been talking about it from the onset before the break. Our guest is, of course, one who has broken down some of the major points, a constitutional lawyer, and of course, legal luminary, Olive, who also is one, would share her thoughts in the process.
But then again,
yes, Mr Jide Ologun. Let's look at the case of rendition, extradition, which has been in a long conversation throughout this entire case. How Nnamdi Kanu was picked from Kenya and brought down to Nigeria, and how his defense have continued to say that it was wrongfully done. Therefore, this has affected the way judiciary is being looked at.
You know, even the Supreme Court commented on that, because you would have heard people saying, oh, the Court of Appeal said it should be released. And yes, the Court of Appeal said so, and that the charges against him be quashed. But the federal government proceeded to the Supreme Court. And since 1963, when we became a republic, Supreme Court remains the highest court in the land. And the Supreme Court said, even though we agree that he was recklessly brought to Nigeria from Kenya, then institute a legal case to that effect. Civil, that's a civil matter. But we are saying that there is also a criminal matter here. Allegations of terrorism and treasonable felony. Proceed with that. So you see where we are now. Proceed with that. And that is why the trial resumed again. And now prosecution brought 5 witnesses in that respect to establish a case that, okay, he has been involved in acts of terrorism and, you know, felon. So, and you now have the right to defend yourself. So the decision of the Court of Appeal had been knocked off by the Supreme Court. And of course, that is the power of hierarchy, because the Supreme Court is the highest court. So now the matter can still be escalated to the Supreme Court from where it is right now. I'm not preempting what the decision of this court will be. But if any party is not satisfied, party can further appeal on it. So let's clarify that. So the issue of how he was brought into Nigeria is still there unresolved. And many of us have expressed our concerns about that. But I recall in the days of the Second Republic, after the Second Republic, when Umaru Diko was put in a crate to be ferried to Nigeria. So those are diplomatic issues. I mean, not many are happy about the way he was brought into Nigeria. But right now, again, like he mentioned in the video we saw earlier, how they invaded his home and he had to jump bail and things like that. So, and that's why he's been repeatedly denied bail again. There are several issues to look into here, and the big surprise now is why he does not want to be defended by some legal practitioners who are willing to defend him. So we are monitoring as we allow the court to decide over
like I asked you before, what are the inherent risks in defending himself, and does he still have room to change his mind?
He has room to change his mind, but you see, like I said, what is on the table now is the issue of timing. Whether the court will allow all those timing and things like that is what I cannot speak over. But he can change his mind today and say, okay, let me bring back my counsels. And that is if those lawyers now agree to return, So, and for those who have been monitoring this matter, there was even a time he told his lawyer to sit down in the court, and, he's used to addressing the court directly. So maybe he has some special skills and knowledge we are not aware of. But at least basically, in the eyes of the law, he's been offered the opportunity to defend himself, because when you are arraigned for alleged crime, you either plead guilty, which fast tracks the whole process, or you plead not guilty. So, and when you plead not guilty, you'll be confronted with prosecution, and then you now defend to establish before the court that you are not guilty. Innocent. And if you are found not guilty, you are released. Again, we also have what we call the weak prosecution. I've said it, in the criminal justice ecosystem, you need thorough investigation, you need diligent prosecution before a committed judiciary. And in the case of Ayodele Fayose, former governor of Ekiti State, he was arraigned, on allegations of embezzling state funds and things like that. But due to weak prosecution, he was discharged and released to go. So those are issues. But here right now, it appears that there has been a diligent prosecution. Now you defend yourself in the matter. And like I said, it's a very sensitive thing for even the president, those who are saying political resolution, because the personality that is the subject matter of the political resolution himself is being confrontational. So
you don't see political resolution as an option?
I've explained the political resolution, because the political resolution also will be judicial in nature, which means the Attorney-General of the Federation can rise up today and say, we are withdrawing the charges against Nnamdi Kanu, and he'll be released. It has happened before. But now again, there's a sensitive issue. We are talking of acts of terrorism against the state. We are talking of treasonable felony. These are serious allegations. And don't also forget that on the international stage, Simon Ekpa had been convicted far away in Finland in matters related to what we are discussing here. So because if you look at the case of Nnamdi Kanu, he established IPOB, Indigenous People of Biafra, in year 2012, and started, established this Radio Biafra invading the space. In fact, that was one of the big issues the former President Muhammadu Buhari had to deal with when he became the president. I remember commenting then that there's a thin line between peaceful protests and violent protests, and eventually he was arrested, granted bail, and we had Honorable Abaribe, the senator, standing as surety before he jumped bail and he was brought back. And also remember that in 2017, IPOB was proscribed by the government of Muhammadu Buhari. So, and he's been brought back. He's been incarcerated since 2021, you know, and here we are right now.
I'm glad you mentioned protests, because that brings us to where we are today. Just recently, there was a protest in the Federal Capital Territory calling for his release, and the Nigerian Constitution does guarantee citizens a right to peaceful protest, but we saw that a court order was sought by the Nigerian police that restricted the protest to certain areas. Does the Constitution allow us to be able to pick and choose what sort of freedom of protest we have? What does it say about restricted protest? And the fact that the convener of this protest, the leader, Omoyele Sowore, has now been arrested by the police. What's the stand of the law with regards to this?
By virtue of Section 40 of the Nigerian Constitution 1999 as amended, you have the freedom of association, and under the same Chapter 4, freedom of expression. But that also is subject to the obligation of the government to ensure we have a peaceful environment as citizens. And in this particular case, the police went to court to seek an order by ex parte means to prevent that protest, which the judge did not grant. That no, put the other party on notice. And eventually the date given was ahead of the date of the protest, and the protest held. And on the side of the Sowore team, they are saying they are not aware of any order stopping them from protesting. So in Nigeria, we need to wake up. You see, I'm not comfortable with all this. We've now seen the order, and the CTC is not ready. We are waiting for this. You see, it ridicules the rule of law. And again, this may be prompted by this issue of bringing political issues to judicial issues. Right. It may not help. Let's be firm with our operations. Okay. And the police has come out to say that Sowore has been arrested in the spirit of fairness, because about 13 others have been arrested and put in a custodial facility in Abuja on the order of a magistrate. And they have confessed that Omoyele Sowore led them to the restricted area. So if we have arrested them and kept them, you also should come and join them.
As their leader.
So, and for inciting public disturbance and going to a restricted area. And then I want to wait and see how, if they are arraigned, those allegations will be established.
I want us to quickly, we have less than 2 minutes, to talk about Aloy Ejimako, one of his lawyers who was arrested during the protest. Part of the statements we've seen, some people say that he has contravened the position of the law and the legal ethics by participating in a protest that may force the hand of the judiciary in a case that he's involved in, which is why they are justifying his arrest. There are others who think he is a citizen of Nigeria, first of all, and has a right to protest and put his weight behind any cause. What do you think the correct position is?
You know, that is referred to as sub judice in law. You see, from the facts we now have and we have seen, Ejimako is not in the main team of the defense counsels. It's just a special counsel to Nnamdi Kanu. He's not the only counsel. And no law in the constitution or otherwise says a lawyer cannot protest, you see. And no law says that you cannot challenge the motive of the protest. So he has gone to express himself, and he has been arrested. So let's see who can prove what if they are arraigned. And basically, let's go beyond these judicial issues. What is the foundation of all these agitations in the country? Because this case of IPOB Nnamdi Kanu is connected to the 1967-1970 civil war in Nigeria. Have those agitations been addressed? You see, that's why the case is sensitive. If people are agitating around the country. In the north, you know, recently I was reading about marginalization in the north and everything. So maybe on the large scale, the government should sit down and look at how we can create commonwealth for common good and address some of these issues. It's not just in Nigeria that we have agitations, but then I think we are too blessed as a nation to have this as major issue in our country. The motto of the Federal Republic of Nigeria says unity, peace, unity, faith, peace and progress. So how can we develop that? Otherwise, we'll just be busy discussing and focusing on, you know, things that should not occupy our major attention.
Leonard Senior, Jide Ologun, thank you for joining us this morning on Breakfast Central.
It's my pleasure. God bless Nigeria.
so
God bless Nigeria.